This is all theater. This is all just political theater.
Political theater. Political theater.
Pure political
theater.
Theater.
Political theater.
The nefarious,
Significant and protracted
Political theater for political theater's sake.
I yield back.
From Washington, this is Political Theater, Roll Call's review of the spectacle of politics on Capitol Hill and across the country. I'm Jason Dick. The Supreme Court has just concluded a term like no other, weathering a pandemic, welcoming a new justice amid a rough election year, and finding ways to address contentious issues like the 2010 healthcare law and voter access. As things get sorta back to normal, we're on retirement watch for Justice Stephen Breyer, and we're also bracing for the court's next term, where cases concerning abortion and gun rights will be heard. Todd Ruger, our senior writer who covers the courts and the judiciary for CQ Roll Call, is here to discuss. Hello, Todd.
Hi, Jason.
How are things going with you?
Everything's great. The term has finally ended, which ends a very busy season for legal reporters. And we're now moving into the Supreme Court has 3 months basically off.
Well, they this is where the justices go and they talk to colleges and legal societies and so forth, and gear up for what could be a big term. Let's talk about the last term first before we get into some of the stuff that we're looking for in the next term. When the pandemic started in the spring of last year, the court was in its they were rounding third base, if you will. They were heading to, they usually, the terms always end in the middle of the summer in June, late June, early July. And, they had to abruptly figure out what we all did, how to meet and hear cases via Zoom or Google Chat or just by telephone and to deliberate on, on the cases. But this was the first full term where none of the cases were heard in person. It was, just talk about how weird that was, because you would go to the court itself to hear some of the high profile cases. Was it weird? Was that like a part of your life that was just kind of gone?
Yes, for people, not only for people who cover the court like I do, but for lawyers. A lot of people that argue in front of the justices, it was strange. We learned at the end of the term 2 terms ago, when they started doing telephone arguments, and those arguments were broadcast live, that anybody could tune in, and a lot of people did. And that created this weird dynamic that you didn't have in oral arguments in person, where justices could pick up on each other's threads of questions. Here it was basically, a couple of minutes for one justice, a couple of minutes for the next justice, a couple of minutes. We heard more from Justice Thomas, for example. And so this year, with this term, when they started in October, they already kind of had that down, and they moved through it very quickly. But you lose a lot of that, and in the middle of all that, you had in November a brand new justice, Amy Coney Barrett. And so they had a term where they were moving, Justice Ruth Bader Ginsburg had died. President Donald Trump appointed Amy Coney Barrett, and that moved the court from 5-4 to 6-3 for the conservative advantage. So you had a new court with a new justice, with a new ideological balance, and none of them were working in person together. And so you just had a dynamic where the court was trying to feel its way through a new situation without being able to work with each other in person, the Supreme Court being closed. And then you had a situation where at the end of the term, they're handing out all these decisions, and anybody can get them at the exact same time as anybody else. They're just posted online. And that's changed a lot of the dynamic around how the cases are reported and how they're analyzed and how they're immediately interpreted.
Yeah, I was struck that, during the first challenge to Obamacare, the 2010 healthcare law, back in 2012, we had this sort of spectacle of people grabbing the opinions from the court, running down the steps to waiting television cameras and reporters, and people reading the, just trying to get like the gist of what was going on, which led some people to actually get it wrong. And then you contrast that with, we had a second Obamacare challenge turned away a few years back, and then this current term, the biggie, if you will, was whether they would overturn it again, whether they would allow the whole law to be struck down because the tax penalty had been put to zero. And you're right, there was no running. First of all, it's all fenced off, so it's kind of difficult. So you'd need high hurdlers, I think, for that to happen. And we all got it at the same time. And so just the physical aspects of getting cases heard, getting the decisions has changed, as you mentioned, and people's cues are different. Like, as you said, Clarence Thomas spoke more this term than he may have in the last 30 years, it almost seemed. And everybody, could tune in at the same time, which has not been the case because the Supreme Court has been criticized for years for not televising its proceedings and not allowing the public in. So all that changed a lot. Let's also talk about like some of the substance of that, though. Let's get specifically to the Obamacare case. This was, a long shot legal challenge by Republican attorneys general to overturn the law after the Congress had zeroed out the tax penalty for not carrying insurance, and so this had been working through the courts, but we didn't see the same kind of fractious 5-4 decision. Like, talk about that case, because that's a big change too.
Right. So, I mean, the situation that the Supreme Court came into this case with is not only were the Republican-led states looking to wipe out the whole law based on this one provision being unconstitutional now that the mandate had been zeroed out, but the Trump administration had backed that. And during Amy Coney Barrett's very contentious confirmation hearing, right ahead of the November presidential election, the Democrats' one of their main things they kept hitting on was that this healthcare case was there, and Donald Trump wanted to wipe out the healthcare law, and Amy Coney Barrett was going to help him do that in this very case. That when they had the vote, they put up poster boards of people who would lose their coverage on if the some of these really popular provisions of the law were wiped out. And so you had a really political fight about this case going into it. And when they actually heard the case, a couple of justices went out of their way to Chief Justice Roberts being one of them, Justice Brett Kavanaugh, another Trump appointee, being another one. They went out of their way to say during oral arguments, like, I don't think that this, the whole law needs to be wiped out. Even if we find this one small thing unconstitutional, we can use this term called severability, which is a long legal doctrine, where you find if the rest of the law can stand, then the courts will find a way to just excise the unconstitutional part and let the full law stand. And so there was a sign early. This case was argued in November. It was a sign early that the court wasn't interested in wiping out the whole law, but it still took them all the way until June to issue that ruling. And when they finally issued it, they issued it 7-2, and it was written by Justice Breyer, who's on the liberal wing of the ideological balance of the court. And it was on something called standing, whether these states even had the right to bring this lawsuit in the first place. And the court 7-2 agreed that they did not have it. So they didn't even have to get into whether or not there was a constitutional issue and whether or not that constitutional issue would then wipe out the rest of the law. So they found this very narrow way to get a broader consensus than either of the big Obamacare challenges previously, which were 5-4 and 6-3. This was 7-2, broader, and really on that big case where everybody was focused on how political the court would be with the 6-3 conservative majority, they found a way for it to be 7-2. And when if you think about, I was thinking about this today on my run, where I thought, okay, if you gave Mitch McConnell six senators to put on a case, and you gave Chuck Schumer, the majority leader, 3 to put on a case, would that case ever come down 7-2 to save the law? Probably not. So you have a way to that the court has tried to identify itself as a legal institution rather than a political institution, when there's all this energy from the left on should we expand the court, should we change the court? There's a White House commission on it. There's legislation to move it to 13 members. And so you had the court, I think, sending a signal there that we're based on law and not politics.
And that seemed to be, I mean, there were more, there seemed to be more opinions that were like that. That's obviously the highest profile one, which is why, we want to talk about it. But I mean, of note, again, here's Clarence Thomas, again, Clarence Thomas joined in the majority, somebody who has typically been associated with, the more conservative bloc of the court, an appointee of President George H.W. Bush. And he joined and said, like, yeah, there is these states that do not have standing. Nobody is getting hurt by having to not pay any money as a penalty for not carrying insurance, which was the provision that was at stake. But it seemed that they, and you've written, accordingly for our illustrious publications, that like this was kind of the defining way that they seemed to forge ahead on most everything, which was they found ways for people to join in, and like they found ways to get almost everybody in the majority on this, which is something that you said that Roberts has been particularly interested in, is trying to depoliticize and kind of stigmatize the court as this just political engine. Donald Trump was not pleased. Apparently, he released a statement saying that Amy Coney Barrett and Brett Kavanaugh had let him down, which is exactly the kind of thing that Roberts just probably wakes up in a sweat at night when he thinks about, like, the presidents would just be able to know exactly what they would get in a justice.
Yeah, it's interesting to think about the court finding its footing and in transition, because a lot of those cases we did see them try to work together to get a broader coalition, and you did see in some cases where the middle sort of held, where Chief Justice Roberts would bring along maybe Kavanaugh, maybe Barrett for the middle, where elite Justices Alito and Thomas and Gorsuch would be on the right, saying we didn't go far enough. And I think it's important to when we talk about this, to keep in mind that this is a conservative court, and it has been for decades, and it's even more conservative now. So that's not to say, like, just because they're finding places to get together that it's not conservative, because it is. And then the other sort of warning signal here for the direction the court is going is that a lot of the cases that they heard this term they agreed to hear prior to Justice Barrett joining the court, prior to there being 6-3, when the Chief Justice still had a lot of sway in which cases the court might hear. And so these cases aren't pushing as far to the conservative side as some conservative people would have hoped. And what you have now is the court taking up a couple of cases that are really looking like they're could be major steps to the right for next term, one on abortion, one on gun rights. And so we still don't really have a good sense of exactly where the court's going. I mean, Barrett has only done a few decisions now. There's only a couple like 54 decisions this term, something like that. So we haven't really seen her full scope of how she's going to approach things. Justice Kavanaugh has only been on there a couple years. So I think all of this is still, in this big feeling out phase, but definitely going to the conservative way.
And it wasn't all, milk and honey either, with the cases. I mean, there was a very notable exception to the, Democrats versus Republicans, basically, like Democratic appointees versus Republican appointees, that came down to the very last part of the term. And that was a couple of decisions on access to voting and voting rights. And that's where we saw some of the spleen venting, if you will, and frustration, particularly among the Democratic appointees, that that was where it did not seem that there was any chance of anybody crossing, the aisle to seek common ground. Let's talk about those cases.
Well, I think the big one is the voting rights case, which was about two laws in Arizona related to access to voting and ballots, ballot collection ban, and about if you vote in the wrong precinct, whether you get another chance. And so what you have is the Voting Rights Act, which was in 2013 through a Supreme Court decision. One of the main mechanisms for enforcing Voting Rights Act was stripped from the Justice Department, which was
right.
They got to pre-clear
right.
any changes to the law, such as the Arizona law in
states that had a history of racial discrimination.
Right. So they got
Arizona, the South, and so forth. Yeah.
Right. So the Justice Department got to see these laws and stop them from going into effect prior to them going into effect. And then when that was gone, then the Justice Department and civil rights groups, voting rights groups, had Section 2 left. And Section 2 of the Voting Rights Act lets them challenge discriminatory laws. And that's what they did in this case in Arizona. It was a little bit controversial whether it was a good strategy or not. And it got to the Supreme Court, and it turned out to be bad because the decision that the Supreme Court did weakens the way that these groups can bring lawsuits under Section 2. So you've got Section 5 no longer there, and now Section 2. And that decision came down 6-3 along ideological lines at a time when there are many states putting in new restrictions. People say restrictions on voting.
They're restrictions. They're restricting people's ability to mail in or vote. Where they may have. I mean, we don't have to dance around the fact that they are trying to restrict access.
Sure.
Whether that's a good thing or not, is a question we can leave for our listeners. But these are restrictive measures that are coming from these states.
I would say they're changing, right? So either whether you think they're good or bad, or good against fraud, or bad against, discriminatory against minorities, they're changing. And when these laws change, groups from both sides can challenge them if they think they're discriminatory. And those are the kind of things that are going to be going through the courts here soon. And what the Supreme Court laid out was not a specific test for what these cases would have to prove, but it made it really, sort of a hard target to meet. To show this, and the one of the things that the majority wrote, which the opinion was written by Justice Alito, one of the more conservative members of the court, basically said that one of the things that states need to do is make sure there's no fraud in elections. And so, if to the extent that their motive is fraud, if it disproportionately affects certain socioeconomic or racial groups, you sort of have to give the benefit to the government that's trying to run a fraud-free election. And that's one of the more contentious parts about that decision, is that it sort of goes into the whole claims of fraud from Trump in the last election, and these states are all putting in these measures that they say are against fraud, but like for instance in Georgia, after the election, a lot of pressure there from Trump about whether the election was fair. Well, they put in a big new elections bill, and the Justice Department has now filed a lawsuit to try to strike it down. And the Justice Department has said that it's discriminatory. So what the Justice Department has to prove now is even harder to get to show. And so the effect of that, I don't think is going to be felt until these cases start going through, because the Arizona laws, they were there, but this case was more about what's going to happen in the future. And there's a lot of doom from voting rights advocates.
And let's talk about what we can expect in this next term. I mean, because we think you can make a very good case that the, so to speak, get it, make a
Yeah, I
case.
get it.
That they, this was sort of a trial run for this new court, but they didn't have to deal with some very sticky issues, like gun rights and abortion rights. But they have agreed to hear a couple of those cases in this coming year. So this could be a big term that starts in October, right?
Right. I mean, this term we didn't see the kind of sort of landmark decisions like legalization of same-sex marriage, for example. Like these cultural things. They're all sort of okay. This could be very determinative of voting rights cases in the future, kind of thing. Or this does not bode well for the amount of anonymous money in politics. Or you could make these sorts of things, but nothing really solid. Well, next term they have a couple of cases that could be very tangible effects on national life. One of them is a abortion case out of Mississippi, and it deals with the time period for when you can get an abortion and viability. And a lot of the law depends on, the Roe v. Wade is the decision from 1973 that first established the right to an abortion. And people that have looked at this issue for years in the law say that the Supreme Court could not just explicitly overturn Roe v. Wade. I mean, that's a possibility anytime they've opened up a case to abortion, but also they might just erode some of these standards that have underpinned Roe v. Wade for a long time, and then the states themselves could pass more restrictive laws that then, restricting the time that you can get an abortion. There's also abortion laws proposed that states about, the reason that you get an abortion. And so this decision could really open the door for a lot of those, even if it doesn't explicitly overrule Roe v. Wade. So that one could change the landscape a lot, especially state by state. And then there's another case out of New York about Second Amendment rights, which is, in a pair of cases about a decade ago, the Supreme Court said that we have the constitutional right to defend ourselves using a firearm in our home. So we have the right to possess a gun in our home, but it limited it to the home. And so states have passed in the decades since all sorts of gun laws. And some of those are about concealed carry and whether you can carry, whether you can get a license to carry a weapon outside of your home. And that's what this case is about. And it for the first time, the court could expand the right to own a gun and possess a gun outside of the home, which, then you have a lot of these schemes state by state differ on how you can get a concealed carry permit. And so it could change the landscape there. You never know how far it might go once they open up the Second Amendment, what they might say in that ruling and how it might open up other gun laws. Because for a decade, they haven't taken any cases such as, assault weapon bans by cities or bans on the size of magazines, some of these gun safety things. They just haven't weighed in. And it's caused a lot of consternation on the very conservative side of the court. So now they have that case and will know. And it's important to also know that those cases, if they hear them and they decide them by the end of the term in June, will sort of be in the middle of political season for congressional races coming into 2022 election.
Potentially, it can alter the landscape on a number of things. I just said in national life, but also, we've been kind of anticipating that Supreme Court politics could affect elections going back to 2016, going back to 2018, 2020, throughout the Trump years and the last Obama year, and it's just kind of unpredictable. It's unclear what could happen, but it would certainly be on people's minds if all of a sudden half the country effectively outlaws abortion, or if your concealed carry license in a state that has more liberalized gun laws is all of a sudden good in Chicago or New York City or Washington D.C., which have more restrictive laws. So it's a big thing. So lastly, about this term, so much of the Supreme Court politicking comes down to Republicans have really optimized their ability to get people on the court, even though they're, they haven't held the presidency as often as Democrats in the last 30 years, and that's caused a lot of heartburn among people who care, particularly on the liberal side. So Justice Breyer was appointed by Bill Clinton. We were expecting, that he might be a retiree candidate, and then, potentially Clarence Thomas too. Neither of them are young men at this stage, and there's almost been a sort of a whisper kind of campaign to encourage Breyer to leave so that he doesn't die midterm and then get replaced by a Republican president or gets held up by a Republican majority in the Senate, and that did not happen on either with either Breyer or Thomas, and it's unclear if it will happen. Is that your read on it too?
Well, I mean, there's like two types of information about this. There's speculation and informed speculation, but it's all speculation, and I think the best way that I can read it is that Justice Breyer is now the most senior on the justice on the liberal side. He gets to when there's a dissent, he gets to pick who writes it, or he can take it for himself. He also had a really good term this last term in that he wrote the major decisions of the case, including the Obamacare case, and so he might see himself as kind of an integral part of that left ideological part of the court. Also, if he retires next year, the Democratic majority in the Senate could still have time to confirm somebody to that vacancy before they lose control, if they do lose control in the November election. So, I mean, there's a number of months there, and you now have the precedent of Republicans who pushed through a nominee right ahead of the presidential election, and so there will be no qualms, I don't think, on the Democratic side to rush through somebody in time. The thing that people bring up then as well, what if something happens to the Democratic majority in the meantime? What if a senator dies and is replaced by a Republican somehow? I mean, I guess, but I'm not sure how Justice Breyer would put that into his calculation. He went out and made speeches about how at least one speech about how the Supreme Court is not a political institution; it's a legal institution. He was out there defending the court, and so his perception of the timing of his departure and everything, he doesn't want it to seem political. It might have seemed political at this point. And he's known as a pragmatist. And so maybe he thinks that the best thing for him to do with, for one of his former clerks, Ketanji Brown Jackson, who was just confirmed by the Senate to the DC Circuit, which is, kind of sometimes referred to as the second most important court in the land. Maybe he says, I'll let her be there for 1 year, and then she'll be a natural pick for President Biden next year, who said he was going to appoint the first Black woman to the court. So all those things are out there. And
I would add too that is just music to Mitch McConnell's ears. He would love it if this was not done in an organized fashion between Breyer and Biden, because that would just advantage him. So whether the court thinks that they're political or not, they basically are. I mean, because Americans think that they are, and are also selected in a political process. So, I mean, this is the issue, for a lot of people, and there is a clear. Republicans clearly view it as a political exercise. And when Democrats say that it's not a political thing, that's why Republicans usually win those battles. I mean, that's how they have. I mean,
right, and you have a lot of heartburn on the left because of Justice Ruth Bader Ginsburg and her decision to stay on the court late in the Obama administration, which even though she had some health issues, there was a pushback then, and she stayed on for a long time and until she died last year. So. You have a lot of heartburn about people on the left have been in this situation before, and they have seen it turn out badly. I mean, if Justice Ginsburg had lived another 6 months, we would be having a Joe Biden pick for the Supreme Court instead of a Donald Trump pick. So
right.
A lot of that, I mean, a lot of where we're at with the court is just the craziness of the world. As you know, and as much as Mitch McConnell takes credit for that, and his strategies and everything, and the Republicans absolutely played into that with Merrick Garland situation and the Amy Coney Barrett situation. As much as that is, it's also just the craziness of the world and how it works and how it's played out in the last 5 years.
Well, I think the craziness of the world is a good spot to leave this podcast and conclude it because it's we do have a little bit of a break here with the court's term, but it will. I predict more craziness, and so that's good because we get to cover it. But thank you, Todd, for sort of downloading on the term that was, the term that's coming, and also the elephant/donkey in the room with future retirements. Thanks much.
Yeah, always good to chat with you about it.